It's Marianna Muravyeva from University of Helsinki, and her topic is New Unfortunates, Degeneracy and Violence Against Parents in Imperial Russia. And our subsednik is Anna Berman of the University of Cambridge. So Marianna, thank you.
So thanks very much, Anna, and thank you very much for having me today. Thank you, Sarah, for inviting me to talk about some gruesome stuff, as I usually do. So people who know my research sort of got used to my usually attracting attention to the unpleasant parts of history and social development. And I'm particularly honored and happy to have Anna Berman as my собеседник. So that's nice to put research to a face, even if it happens on Zoom. So I'm going to share my screen now. So to have a bit of a PowerPoint, it's rather mostly about pictures than with any substantive material, just to give a little bit of a taste, a visual taste of research. So a little bit of a couple of disclaimers for this research. It has been published. We had been doing so this part of research as a sort of part of my ongoing research into histories of family violence and particularly violence against women. The monograph in Russian will be published this year by the end of the year on, and it's called Till Death Do Us Part, 4 Centuries of Family Violence in Russia. And I've chosen to do that in Russian to also provide material for the Russian audience, including activists, including policymakers, with historical patterns of developments in legislation on domestic violence, and it's connected with, of course, our recent campaigns for promoting domestic violence and family violence and prevention of family violence legislation in the Russian Federation. We have not been successful, but I do hope that we do still have a chance to achieve our goal. And in this research, I show that and provide people with the material that the Russian history and Russian development has not been as unproblematic as activists or politicians present it to be. We all know what it is. And this particular part of the project is on violence against parents. I contributed also to the contemporary discussion on tradition and traditional values, and claims that traditional values are basically based on a particular type of the family and absolute respect for parents, and the idea that nobody ever whatsoever killed parents or insulted parents, because culturally that is not what it is. And this project also is comparative, and I'm going to show you. So when we started doing the project, actually, we started with 2 colleagues of mine, one Finnish colleague and the other is a Canadian colleague. We all come from very different backgrounds. We started with with looking at sort of creating certain types of moral panics, such as this. That's from a British newspaper. So parent abuse on the rise, and you have that whole idea, but it never happened before, and now it's happening. And so in the contemporary situation, it happens for 3 reasons. So whether it's a prior child abuse, so retaliation, it's a mental illness, or it's antisocial behavior. And that's any literature you take that basically goes back to that. And a lot of mass media, social media reports, or what presents the analytical material actually basically built on that. So we departed from today and started looking into plenty of historical material that we've had. And my project, as well as my colleagues' projects, were based on the analysis of court cases, and a legal narrative, as well as cultural narratives. That's a book we've done, and the contemporary presentation is in fact chapter 3 of this book. If you're interested further, so we published the final monograph on parricide violence against parents on a global approach to cross-cultural view across past and present with my colleagues Philip Sean and Maria Toivo. And you can see the contents on a slide again. So we looked, in fact, into various time periods, but also into various geographies to arrive to pretty much interesting conclusions. So that's sort of position research. And again, I'm going to be giving a rather short version of it today. So please don't hesitate to go look up both books. It's quite an interesting material, also comparative material. So especially here, we provide a variety of chapters from very different scholars in different periods. So mine also fits quite well with other 19th century chapters in this book, just to create a bit of a Nordic and US European perspective. Okay. So let's go back to the 19th century. So as I just explained, 19th century is just one part of the timeline. So I've done the 18th century, the 16th century, and so before that, there is an article on 20th century. So 19th century is in the middle of it, providing an explanation and also approaches to adjust violence against parents with a focus on degeneracy and degenerate theory, narrative theory, as an explanation for, in particular, violence against parents rather than any other crime within the family. All of us who have done 19th century, of course, are familiar with the predominant narratives of degeneration and decay in moral principles of the working class and remote minds, in other parts, the social criticism of illiteracy and social problems of peasant population. The particular quote from Sergei Maksimov, that's a famous book on Sibir Ikatorga, published in 1971, provides just a gist of this criticism. And if you are a Soviet person like myself, when you grew up and went to a Soviet school, so that's exactly the picture of the 19th century that we had in history lessons. And I went to the uni also, still were Soviet time. So that's basically what you get for the 19th century in terms of trying to bring you to the idea that revolution of 1917 obviously was necessary. So as one newspaper put it, the power of darkness, that's what accounts for all these drunken brawls and fathers killing their children, killing their parents in retaliation, of course, spousal abuse, women being abused and prosecuted, etc., and all of this sort of pointed out at ignorance and moral underdevelopment of the Russian population. And on the top of it, you can also see narratives and, again, newspapers and broadsheets and whatever reporting on excessive drinking, on other sort of social diseases. And what is interesting, though, in these narratives, and that is interesting to me, of course, somebody who usually does early modernity and looks at it in the perspective of how these discourses change and narratives change, is that the same cause, or what sort of supposed to be a predominant cause for killings, say excessive use of alcohol, for example, becomes framed completely differently in those narratives in the 18th century. Before that, it's just drinking, not just drinking, but drinking is a moral problem. In the 19th century, drinking, and I'll sort of talk about it a bit later, becomes a sign of degeneracy. Alcoholism is medicalized, so medical condition obviously leads to killing. And that's why the article also is called New Unfortunates. They were unfortunate before to happen to kill their parents, but now in the 19th century, it's a new approach to being unfortunate, because they're not. It's not that they made a choice in the predominancy of discourses, especially by the end of the 19th century, but they were preconditioned to do so by looking at a human psyche by the explanations such as degeneracy or mental challenges. The 19th century is interesting also from the other sort of point of view for me, again, doing the long-term research, is that the family becomes a battleground of conflicting attitudes on the permissibility of discipline and reconfiguration of the borderline between discipline and abuse. It's not that the situation in the family and violence in the family wasn't discussed before. Of course it was. And I've spent quite a lot of time and by publishing sort of energy to show that in Russia, that discussion was actually quite vivid. But in the 19th century, it takes a little bit of a different, again, of a different light. And if you look at the legislation, you immediately notice that codes now start paying much more attention to crimes within and against the family by including extensive sections devoted specifically to family conflict. So in before, Russian legislation always accounted and allowed to prosecute spousal violence and violence against parents and violence against siblings, for example, and other family members. And that's with the exclusion of children. Again, I'll return to that in a minute. It's never deserved such an extensive attention from the official legislation. And I'm not now talking the discussion among legal professionals or what we call doctrine. So generally, there was an agreement among commentators and lawyers that parricide, so killing a parent, did not warrant mitigation. So there was in line with a tradition of previous centuries, there was like no excuse of killing a parent, period. While at the same time, for example, infanticide did provoke pity and remorse towards these mothers, or filicide, so killing not a newborn, but a child who was older than one, for example, especially if that wasn't an illegitimate child, always provided a room for mitigation, and parents who ended up on trials for killing their children, if they ended up on trial for killing their children, often got a much lighter punishment than if the child would have been killed by somebody else. So there was a recognition and this balanced and asymmetric approach to children killing parents and parents killing children. And it had been there before, but in the 19th century, it becomes very visible and very explicitly discussed as to why and how do you sort of provide that space of family conflict in which parents have all the instruments of law to defend themselves and to bring charges against their children and to use courts as instrument of discipline if they could manage their own children, while in fact children, whether small children or adult children, did not receive these instruments. And the authorities and legal commentators focused on this parent-child relationship, was seen as a foundation of social and political order, of course. And it's again obvious, and all of us have done a lot of work on that, that the whole idea behind that, starting with Catherine II and her sort of moral reconstruction of the duties of citizens in this new society that she was also building, and these children were brought up in unquestionable or unquestioning obedience to their parents. And this made them good citizens, loyal and obedient to both their superiors and to their authorities. So in a sense, not allowing children to prosecute their parents was often a result of bigger ideologies of trying to create obedient citizens, and obedient citizens, the obedience started in the family. And of course, if you remember the police regulations of 1782, there are famous description of duties of family members. So while parents are masters of their children, and their natural love towards them defines their duty to provide food, clothes, and good and honest education appropriate to their social status, children, on the contrary, have an obligation to pay their parents wholehearted respect, obedience, humility, and love, and suffer parental correction and admonition patiently. So the project of creating sort of obedient citizens who respect the authorities and foster respect to the authority, starting with parental authority, was embedded in how parents and children were viewed, and how their duties were constructed, and what they could and could not do in terms of relationship with the state and law. So basically, parents could use the full force of the law and the state to prosecute their children for any infraction, while children basically were deprived of that. I'm not going to go through regulation in extent. As I said, there's plenty of publications myself, well, mine first of all included. What's interesting that there were several types of venues in where now this conflict, the family conflict, was given an opportunity to be looked at. One of them was traditional. It didn't exist that long, by the beginning of the 19th century. A Sovietsny Sud, equity court, which operated between 1775 and 1866. And the jurisdiction of this court was to preside over conflicts between parents and children specifically, which was in the description of the court's jurisdiction, and other petty crimes in addition to property conflicts and civil matters. And in 1802, one of the manifestos coming from the newly enthroned Alexander I, who of course had a very difficult relationship with his father, and obviously we all know what happened to Paul I and Alexander's role in Paul's death. So in the Royal Manifesto in 1802, conflicts between parents and children were particularly paid attention to, and equity court was placed in a sort of center of dealing with this conflict, because it was in an equity court that justice united with benevolence, and that's what was required to look and to deal with those who committed crimes, either with a disturbed mind or in a state of corrupted morality. So equity court was the space in where parents could prosecute their children, and where actually children could have argued their case, but in a sort of the situation of legislation that wouldn't allow children to argue their case, it didn't happen. Although equity court was actually quite a good space to pay attention to why children committed abuse and killing of a parent. So the other space that we all know really well, and that's on this slide, Wallace Court, Volosny Sudy, community courts, those are the results of the emancipation, of course, in the legal reform of 1864. And in fact, the equity court entered its existence in 1866, while Volosny Sudy, Wallace courts started its existence in 1864. And court regulations for Wallace courts, of course, that were created by the authorities to give an opportunity to peasants to continue with the tradition, and which basically I argue in my research, they invented this tradition based on the manorial justice. What we call customary law basically didn't exist. They created the customary law based on the manorial justice of the previous 2 centuries. This court, the Wallace court, took the function of looking into a lot of petty offenses in the community, particularly involving peasants, within the acts, within Wallace, within the respective rural community. The majority of those cases over property, but all the minor assaults, disorderly behavior, slander, insult charges also ended up there. An absolute majority of those cases involved family members in one way or another. Again, any of you who worked with the cases from Wallace court, and thanks God, some of them are published, the majority of them actually published in the TPKV, but also there are some unpublished archival cases, but the absolute majority of those cases, in my calculation, and I didn't do a very accurate calculation, but in an accurate calculation that I've done, based on the published materials, about 82% of all the cases involve some sort of a family conflict. And among these, there's 50-50, which is unusual, spousal quarrels or quarrels with parents or between parents and children. A lot of them involve property, but not really. So in a sort of community courts or in the Wallace courts idea, again, respect for parents was a part of good behavior and social order. And the elders who were elected among the community, in fact, followed and uphold this idea, themselves being parents and grandparents, sort of trying to create this protection for the natural order. But the difference between equity court and Wallace court, actually Wallace court allowed children to mitigate their behavior, especially in cases like, for example, when a 36-year-old peasant, when he was prosecuted for the assault on his father, so he broke his father's ring finger, and so he was brought into Wallace court. And so that's one of those cases where the elders actually allowed a lot of mitigation, but mostly because the family stood by this peasant. His name was Piotr, and the family altogether accused the father of the family, so Piotr's father, of constant domestic abuse, frequent beatings of his adult son, drinking, indecent behavior. And so the picture on a left, you can see it's a sort of one of the most typical sort of altercations between the father and the son, or between adult sons, for asserting, reestablishing male authority. And in this case, that comes from in 1866. Piotr was sort of characterized by the community, by the neighbors, by the family, as very respectful. He did what his father told him. His father, for example, would kick him out of the table without food at the age of 36. So Piotr was married with 2 almost teenage children. And in one of the moments when the father got really drunk and started kicking his son, so the way the neighbor described that the son was protecting himself from blocking the hit, and that's how the break of ring finger happens. And sort of the Wallace court, although the elders told Piotr that he still disrespected his father and still didn't have enough patience to survive the abuse, because still father's authority was absolutely there. But at the same time, Wallace court took into consideration the total family's support and father's behavior. That wasn't a model behavior of a patriarch of the family, and although did not fully acquitted Piotr of the disobedience crime, but at the same time did not punish him the way it is usually punished, and it's usually either arrest for whatever amounts of time. So, but at the same time, Wallace court insisted that the father reconcile with his son. That, of course, also resulted in a further escalation of the situation. And in fact, Piotr returned to this court 2 more times, exactly for the same charges. So in a community court situation, that's the difference with the Soviet equity court, which is more of a state sort of sponsored court. You could see a bit more space to question the parental authority, especially if parents' behavior was not up to the standard of the community. As we know, Wallace courts actually mostly had jurisdictions over emancipated parents in the second half of the 19th century, and the other parts of the population, which is a minority of the Russian population, who lived in cities or belonged to middle classes and the nobility, they all, of course, were had other instruments to access to justice, and a lot of these instruments were connected with the Justices of Peace, again, the new institution until the 1864 legal reform, but also to circuit courts that actually looked into criminal offenses. So in the situations of escalated killings, of course, neither Wallace court nor equity court were the places to go. And that's, again, an interesting situation in which you see quite different narratives of how the court approaches to to parental authority and to the idea that that authority is natural and absolute, and obedience to parents should be done natural and absolute. In the beginning of the 20th century, although the trend started before, you could see a lot of developments in how heinous crimes now are framed. And I'll start with a 1902 case and walk a little bit sort of in time back to just work with the degeneracy theory, the one that features prominently in all my killings of parents, the cases that I've collected working in the archives for the 19th century. So as I've said on the contrast before, when you have sort of in the previous slide, the trivial abuse, trivial in the sense that it doesn't lead to lethal violence. It involves what is seen to be a family conflict and a squabble, which is partly a important thing to deal with a community, because the family is this model for the way society lives when it comes to parricide, so to killing a parent. So there is a different mechanism and a strategy in place. So in 1902, there was a famous case, and I'm sure that a lot of you have come across it, case of Alexander Kara. He was a son of a very rich brewer in Moscow. Kara breweries were quite famous. And he appeared in front of a jury for killing his mother and two younger sisters. He used a hatchet to do that. And he did that for the most banal of motives, of reasons. His mother had discovered that he had stolen money from her. So he killed her. So she caught him red-handed while he was removing money and jewelry from her trunk. And so he killed her, and then he killed two girls, his sisters, and his younger sister was 11, because they witnessed the crime. So apparently, in his explanation, he confessed immediately when the police arrived. In his explanation, he said that he was courting a young woman, and he wanted, and he knew that she didn't love him. So he, but he tried to keep her as his lover and then his fiance, because he wanted to marry her with buying her luxurious gifts, but he actually didn't have his own money, so his allowance wouldn't allow to provide luxuries. So he was pilfering money, cash and valuables from family members for a year before his mother caught him. So what happened in court was interesting, because cases like this came to the attention of the authorities, not often, but they did. However, the absence of remorse on behalf of Kara, when the police arrived, he did not run. He did not even make an attempt to do that. So that sort of pushed the public defense, first of all, but also the jury to suspect something was wrong with him, because he was behaving unnaturally for a criminal. And naturally, in their opinion, for the criminal would be to try to escape or cover his tracks or say somebody else did that. So he didn't do that. So the jury, upon the assistance of the defense attorney, ordered a psychiatric evaluation to find some answers to his odd behavior. And it was interesting again, because the judge was completely against such a decision. So for the judge, on the contrary, the behavior of Kara was actually attesting to his complete sanity rather than insanity. So he was provided with a psychiatric evaluation, and the court and the jury were sort of very adamant to have a conclusion from the forensic psychiatry. And when the defense attorney presented this conclusion, and the conclusion was based on the degeneration theory. It's not the first time that the defense used it, but it was just the first time that somebody as prominent as Kara, coming from a rich family, and also 1902 was a particular year. I'm not going to go into that. There is Louise Reynolds' book on the murder of Russian, so she pays quite a lot of attention what's happening in the sensationality of a courtroom and the juries. So you could actually look into that as well. And so when the public defense attorney was presenting his defense, he started going into how Kara was manifesting classic degeneracy and going into his genealogy to show that. So apparently his maternal uncle killed himself after a long-lasting melancholia. There was a grandmother who had been committed to an asylum for several years and had tried to kill his father. Then Kara had a crooked chest and hunched shoulder that was signs of physical abnormalities, which attested to his own mental problems and did not allow him to be drafted into the army, etc., etc. So the narrative of the court trial describes him as a short little boy with a thin and a yellow face, lightly touched by facial hair, again creating this demonic picture, degenerate picture of the accused. An attorney sort of played with this and insisted, with the fascination from the public and support from the jury, that Kara belonged to a mental institution, psychiatric hospital, rather than to Katorga and to Siberian mines. And that's what happened, that the jury found him guilty based on as a result of insanity, and so he was sent to a psychiatric hospital. Although he didn't end up there, what happened that a year later he was retried and finally sentenced to the penal labor in Siberia. There would be different circumstances. So on the slide, you can see a typical manuals 1900 manual by Arshansky in Court of Psychopathology, Psychopathologia, that was actually quite well cited and commonly cited, and it was cited during the trial. And one of the pictures from another manual that portrayed criminals as degenerates as a result of degeneracy there. And you can also see the captions below the picture, that there's a genealogy of crime, of course, all the Lombrosian about it, and that sort of obviously leads to more criminal behavior. So Kara's case is quite important, as it was a culmination of the public fascination with new criminological theories, insanity, sensation, monstrosity, and all the dark side of the human psyche. Jury trials provided quite a lot of input into fascination with it. It was this type of entertainment where enjoyment with monstrosity bordered on unhealthy in a society, but of course not everybody was invited into the courtroom. It was also up to upper classes to sort of perpetrate that, and again Louise Reynolds writes about it in her book. And it's interesting that instead of the actual discussion on the social, economic, and political reasons for domestic crimes, for killing parents, instead of actually pointing, drawing attention to inequality, gender discrimination, for example, patriarchy, and other reasons that should have been and were cited as possible motivations and reasons and explanations for killing parents, the public and criminologists were much more attracted to Lombrosian explanations of this especially heinous crimes, as in Kara's case, killing mother and two young sisters. And it's interesting that in these narratives, it's not just one case. There's a number of cases where degeneracy prevails, whether the accused was in fact mentally challenged or not. And I look at it as the possibility, the necessity, rather not a possibility, the necessity during these very unstable and trial times to provide an explanation that did not include a choice or the idea of a choice, that somebody could choose to actually kill, their parents in cold blood, because that is something which, although quite a popular motive in literature, do all of us read detective stories of the 19th century where a nephew or whatever, Sherlock Holmes or Conan Doyle, one of the good examples, where a nephew obviously or children plotting against their, whatever father or an uncle or whoever to get an inheritance. But in fact, in reality, if you look at the motivations for those crimes and the situations in which children kill their parents, at least sort of in the material that we've worked with, and again, the Parasite book is very good for that, as we have that view of Europe and even beyond Europe and countries such as Japan and China at the period as well. The interesting thing is, like, I hate to say never happened, but it rarely happened. In fact, the majority of killings that were committed had nothing to do with the fortune or inheritance or motivation. So you have that discrepancy. And in court, the whole idea of allowing a rationale motive, such as, for example, inheritance, was considered preposterous, and the psychological and mental illness explanations and the degeneracy theory took a precedence and was sort of viewed as a convenient explanation for that. There were a number of other cases, again, you probably heard of. There was a case of Sergei Maksimov in 1911, a very similar case in which there was a battle between psychiatrists and lawyers. That's prosecution and the judge. Then defense sided with a psychiatric assessment in which, again, Martyonov, who killed his father but tried to cover his tracks, was presented as a degenerate who couldn't really make choices, and the famous Moscow psychiatrist at the time, Sibir Ikatorga, actually argued that if he were not of degenerate line, and he presented that there's a publication, Taylor has actually published his assessment, so he wouldn't have killed his father. And in fact, Taylor argued that as degeneracy was a hereditary disease, so parents actually were also accountable for their own death. So in a sense, it reads quite interesting in a situation that is predating quite a turmoil in Russian society. And a couple of minutes I want to, before I finish, I want to pay attention to one of the good examples as to see how that changes and how the society is reluctant, in fact, to allow the social and economic conditions to be the main explanation for killing parents, and instead prefer the preferred explanations that sort of deprived the perpetrator of their choices, is the cases with alcohol, and the whole literature that started appearing in the 1840s and coming onwards, part of the temperance movement, alcohol consumption as part of the criminological theory, and the whole idea that drinking was in fact a sign and a condition and a consequence of degeneracy. And in fact, if a person was drinking, then he or she must have been a degenerate. In a sense, again, that is an interesting explanation. It was a totally different explanation from what you have in the 18th century, for example, when they discuss alcohol and alcohol-related crimes within the family, when drinking was a choice and also a moral choice and a part of a moral behavior. Now drinking became a disease, and I dare say this attitude to alcoholism is a contemporary attitude as well. So there's been a lot of cases, and again, if you look at the sort of balance of those cases, in absolute majority of those cases, except for the Martyanov case, alcohol was mentioned. In Kara trials, because his father was a brewer, The public defense attorney insisted that he also had a history of drinking from younger age because his father was not diligent enough, and his father actually allowed his children, younger children, to drink beer, which of course led to full-blown alcoholism by the age of 21. There were other cases. There was one of the case of there was a Bajanov case, and in that case, Bajanov killed his parents and left them in the house, and he was sitting in the front stoop of the house, waiting for the police to come, totally drunk. And then the police surgeon, while providing expert testimony, described that as a classic behavior of a degenerate alcoholic. So not only he didn't have remorse, he didn't try to escape. He was there, and he couldn't name a motive of killing their parents. So to conclude, as I'm out of time, yes, 1 minute. In these trials, by contrast with what I call the trivial sort of quarrels, it's absolutely obvious that there is a change in how society and the authorities approach and treat disobedience to the authority during the profound changes in the 19th century. So in a trials such as the trial of Alexander Kara, it's obvious that there is a reluctance to accept a possibility of rational behavior in a situation of killing parents, because the explanation that the behavior is irrational and conditioned or preconditioned by degeneracy is an easier explanation, as paradoxically as it sounds, than the allowance for rationale and premeditated intention to kill the authority in a natural order. I would say that this trend is then visible in how authorities also sort of approached the other types of rebellious behavior or protest against the authority. And so looking at killing parents, and a particular sort of a way that was framed in those courts as unrational, degenerate, influenced by preconditioned alcoholism or other mental disturbances, in fact, sort of was something that authorities were looking for in order to also avoid rationalizing protest against them. Thank you.
Marianna, thank you very much. That was fascinating. Anna Berman is our subsednik. Anna.
Huge thank you to Marianna for this incredibly rich paper. And she sent me the whole chapter, so I've got a little bit of additional material to work with here. I really appreciate, first of all, her approach, using legal history to cast light on larger social issues, and particularly ones around the family. And this is something that I think is so important, and I would love to see more of it. I've been reading her work for years, so it's very exciting to finally virtually see her here. So I think what she's done here partly is bring to light some absolutely fascinating, gruesome, and interesting sources that should, for those of us on the literary side, also change how we read some of our classic texts. And I will get to that a little bit in my discussion. I see my role is just to kind of open things up for discussion. So I'd start with, there's several, to my mind, big overarching questions that sort of underlie what Marianna has been talking about. And one of them is, at most basic level, why do people believe what they believe? So Marianna opened with a claim about the gloomy picture that commentators are painting of this kind of, and I quote their depressing social state of the Russian population in the mid-19th century. So one question is, of course, was it really so depressing? As she hints at, we often say whatever period we're in is the depressing one. So was it really worse, or was it just that these cases of familial violence were getting more attention or being viewed in a different light? Interestingly, that quotation that we start with, that was up on the slide, I think, about this gloomy picture, that's describing the working class in a remote Perm region. So I guess one question is also, what picture did educated readers want to see of the recently emancipated peasants in this period? So throughout the paper, there were kind of a series of factors at play. And I think what I'll do now is just try and tease them out a little bit, sort of name them almost, so that we have a point of departure. So one factor that I was quite interested in, and I guess would love to hear more about, was class or social estate. So how violence is enacted differently in the different estates, and also how the reading public would view it differently, depending on, and not just the reading public, also, I guess, juries, depending on class background of the perpetrator. So we've got cases here of peasants, of a wealthy brewer's son, merchants, what happens when it's amongst the gentry. And I'm also curious, geographically, does it matter where this violence is happening? Is it different if it's way out in Perm versus whether it's happening in Moscow? So that's something I would love to hear more about. I think the next kind of factor that is really important here is this shift across the century. And this is something that Marianna is really beautifully kind of teasing out, but that we're moving from a much more traditional family model towards one that's based on more effective bonds. And this is aided by the changing laws and social structures. And then also at the same time, these rapid developments in science and the way people are thinking about psychology. So the object of study here is also a bit of a moving target, right? As we're tracing an evolution as opposed to something that remains static. And I think we have to also keep that sort of in the background of this conversation. And then related to this change in time, of course, the different kinds of courts and how those are each going to respond differently. And then the addition of jury trials, and then they're adding in a public viewership, which is going to be from the gentry, as was just talked about. So I think that's another factor. And then in terms of other ones, we should bring in the emphasis on social institutions and structures versus on individual human nature and psychology. So is this about patriarchy and gender discrimination, right? Or is this about degeneracy? And linked to this, the shifting views on alcoholism. Is this a vice? Is this a disease? And what was beautifully laid out in the chapter, and I think mentioned here, but I love this line about basically lawyers start losing out to doctors in these court cases. And that to me was a fascinating point. And then finally, the question of the realities of what's going on in the Russian family versus what people want to believe about the family, right? So this idea that it's too upsetting for a jury to think someone could actually rationally kill their parents. So we've got to look for another way to view this. So it's not even about what's happened, but about how we feel about what's happened and what we're looking to see. As Marianna noted in her talk and as her work overall shows beautifully, right? This problem of familial violence is not unique to this period. It runs through all of Russian history, and it runs through all classes, from the czars, of course, accidentally killing children and otherwise, through to the working class, to the peasants. But the 19th century is a particular moment and a fascinating one to study because of these massive changes happening in the Russian family, right? This is the reform period. So we're not only talking about the emancipation of the serfs, but also the rewriting of imperial family law. And that's something that gets talked about elsewhere in your work. But right, we're moving from what you mentioned here as patriarchal authority being natural and absolute, so this kind of obligation and obedience model, towards this more effective model where a certain kind of care is expected and required. Also important here, this acknowledgement of the lack of protection for the vulnerable members of the family. This is something we start seeing in a lot of articles about family law and the needs to reform it, right? That wives are legally obligated, as you've written about so well, to live with husbands who have no legal obligations to raping or beating them. Children cannot marry without parental consent. So as we can see here, sons can't, provide for wives necessarily. Daughters have virtually no escape from the parental home. Illegitimate children had absolutely no rights. These are all old focuses that I'm bringing back in, but Marianna's written about them elsewhere. But I think this idea of this new concern of actually protecting parents from their own children adds a fascinating new twist on this. And Marianna shows that actually the government gave itself a huge role in regulating and shaping what's going on here within the family. So intervening in these family disputes, but always taking the side of the parents, right? Not allowing children their own day in court, so they can't go prosecute their parents. So they've set up a system of laws that really protected the parents. Property rights come into this. As you said, most of these cases aren't about property, but in some ways they sort of are. So unlike in England, where we had the custom of primogeniture, everything goes to the eldest son, Russia has partitive inheritance, right? So the inheritance is spread among all of the children, the estates get split. So we often think the tension would be between the inheritors, right? Brothers fighting over who gets what. But actually, what I think you bring to light here is that these court cases and these tensions are often about fathers and sons, about the question of when does the estate get split, right? So until you actually give that stuff to the son, he's got nothing. And so this question of when you create the division. And these issues are particularly fascinating to me, right? Because they all play out in the literature in so many different ways. And so in knowing what's going on with the real families, I think helps us make sense of the debates that the novels are actually participating in, because they're always engaging with these same court cases that are getting written up that these authors are reading. A not very well known now example would be Alexei Potyekhin's once very popular Biedные Dvorяне. This is from 1863. It's all about these kinds of tensions. You have the one industrious son who's been working the land, and you have the other son who's been sent off to the army and comes back as an alcoholic, and he and his father are basically just drinking together. There has been a division of the land, but not officially. And so at a certain point, the father lets the alcoholic son go take, plow the other son's land while he's off in the city. And then you get to a huge amount of fighting. You don't actually get a parricide here, but I think all the tensions that could lead to one, you can see how they would play out. This question of when to divide the property also comes up in subtly, but in Tolstoy's Khazyain and Rabotnik, Master and Man, right? Brehunov stops and visits a peasant family where there's a question of this. They haven't split. The sons are feeling this tension. They want to. So it's sort of in the background, but it's lurking all over the place. And then, of course, the novel that speaks most clearly to all the issues Marianna raises is, of course, Bratia Karamazovy, the brothers Karamazov. So here we are featuring a court case of a son on trial for murdering his father. Drinking was involved. They were in a dispute about property and inheritance. And that novel, of course, brings into focus these debates about blaming societal issues and structures like the alcoholism, like inequality, and also blaming individual human nature. So it almost could have been a case in this talk, right, that the fiancée, Katerina Ivanovna, calls in the fancy Moscow doctor who makes a case for abnormal condition and a fit of passion. This is just like the cases we heard today. And then the prosecution and the defense are going to argue over how much responsibility Dmitry actually holds and how guilty he truly is if he is the one who killed his father. So the defense points specifically to the jury's horror at the idea of parricide. Exactly what we're talking about. No one wants to acknowledge it. And he says they would certainly acquit if this were just a case of murder, but they somehow can't let it get off. And he tries to make that a case that it can't be parricide because Fyodor Pavlovich had failed in all his fatherly duties. So he claims, right, that a father who didn't love and support his children doesn't deserve the name of the father. So he's trying to actually shape whether or not the case is about parricide. And it points to, again, this shift in family values to this new effective model where it's not just blind obligation and duty. And just because you begot a child doesn't mean you're a father. You have to have actually cared for the child. And also, like what came up here, I was interested to see, he blames Dmitry's drinking on his father's alcoholism. So the sense that the degeneracy is actually inherited. So it's partly Fyodor's fault that this is what's going on. So again, just to wrap that point up, I think to know something about the actual history is so important and helpful here, because we can see what the debate is that Dostoevsky is participating in, and shows us also how much this topic was in the air. So as just a final sum up point, and this is something that wasn't so much in the chapter, I thought Marianna was going to steal my last point at the beginning because you started going there, but at a fundamental level, to my mind, the threat here in all of what we've been talking about isn't really just an individual son killing an oppressive father who's withholding his portion or forbidding his marriage. It seems like, if we think about how the family was often viewed as a microcosm of the state, as was mentioned, right? The czar standing above his children, the people, just as the serf master used to stand above his serfs, right? This is a system that's designed to protect the man at the top. Children have no recourse to the courts or to petition for justice. And we're approaching a time, we get almost up to it in this paper, when the sons will not be content to accept their powerless lot. So in a sense, I think what Marianna's paper may be providing is a bit of the roadmap to how Russia's defense of the parents ultimately actually pushes the sons to rebel, not only in the small family, but in the great one as well. So thank you so much for that.
Anna, thank you very much for that response. Marianna, would you like to respond briefly before we open up the floor to questions? I'm sure there will be questions.
Yeah, I think we can open up the floor for questions if Anna doesn't mind, because I mean, it was a rich discussion, and I think Anna just basically pointed out to a lot of points that I would have loved to develop, but it's just 40 minutes, right? So we don't have much time, but again, the chapters are there. Just the only thing is, I would just pre-dating the discussion is that there's the point on property. Of course, it's about property, but the way, and you mentioned yourself, what we believe and what the reality is and how it is framed is a whole different way. I mean, of course, it's about property, and it's about also asserting masculinity and trying to be their own children. Mostly it's for men, and contrary to what I usually do today, I actually didn't focus on gender and patriarchy, which I usually do all the time. But so this talk was a little bit about questioning authorities, but it's about men. It's about how those masculinities become violent because they're not, they've been obedient and repressed so much because you can't rebel, or you can't even complain against your parents. Even you don't need to even assault or insult them, but you can't even complain in a reasonable situation when, in a lot of cases, when your father or your parents, that mothers included, mothers-in-law, you know, are very abusive of what's going on. And the Wallace courts are all about it. I mean, the sons want to split the estate and want to be their own person, but the father and the mother don't want it because they lose labor, they lose taxes, they lose, I mean, they have to pay more taxes, they lose money, blah, blah, blah. So that's a lot about it. But the way it is framed in court is a totally different narrative. And that is what is fascinating to me, because in the 18th century, for example, in the similar cases, it is what it is. There is a very particular discussion about it. So even when they try to say, oh, you know, my father is abusive, blah, 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 the judge would be, no, 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 you want to split this state. That is different, right? So that's like a vice versa discourse. And that's what actually got to me, you know, in the sense that we all understand what it's the same crime, right? But the framing of it is at all different in, of course, the circumstances, and which tells us about something, right? About how the society changes. But it's just predating the debate. Okay, thank you. Thank you, Anna, very much.
Thank you, Marianna. Questions?
Well, but people are gathering, you know, I could point out the other thing. What's interesting, again, in the 19th century that emerges very subtly is blame the parents discourse, you know. So in the court cases that we see before that, and it's a lot of those, parents are just in their own right. They go to court and they say things, yeah, I've been beating my son, I've been abusing my daughter-in-law, and they dared insult me. And the court says, yeah, no, you shouldn't have done that. And the court would be, especially in the Catherines, during the Catherines times, when you also see the emergent separate judicial system, when already you have a hierarchy of court, which is different a little bit before this, sort of before the 1760s and 80s, 70s and 80s. And the court would be, yes, this is bad, right? You shouldn't have abused, and you shouldn't, of course, you know, sexually harassed, and, you know, and things like that. And yet the child should have withdrew from the temper or anger of their parents, and basically the child is still in the wrong. And that's about adult children. And a lot of these cases, what today we would have think about, I'm thinking about Khachaturian sisters, right? You know, participated in this case as a consultant quite a lot, because it's a classic case in which you have this reciprocal violence on behalf of daughters who just couldn't stand it. And we're talking about historical sort of continuity. I have a lot of cases like that in the 18th century when daughters killed their fathers as a self-defense after years of endured abuse, or by protecting, for example, younger siblings, or by trying to protect their mothers who've been, you know, surviving through the abuse. But anyway, the courts are always on a position that the children should have withdrawn, they should have avoided, they should have suffered, they still should have exhibited this obedience. While sadly, in the 19th century, when you look, especially when you sort of go through these cases, and particularly this happens somewhere around 1840s. So Nicholas, who tried to sort of continue Catherine's tradition, goes away, and so Alexander II and the reform and the turmoil in Russian society. And then you see this slight change, and I think mental sort of challenges and idea of degeneracy, and this explanation sort of provide for that. The idea that you blame the parents, that children are what they are because also the parents made them so. And therefore, although we still support the parents and still patriarchy, we still uphold authority, but At the same time, we sort of subtly also bring in the possibility for children to at least have a little bit of a mitigation, a little bit of a reprieve, not to go to Sibir Ikatorga, right, to stay in a psychiatric hospital. So in a sense, that is, again, a very interesting change, which happens in some other countries earlier. For example, in Britain, it happens a little bit earlier, where you can also see that change. Blame the parents change, as we call it in the contemporary criminology. Just again to give some thoughts to that.
I see Sergei Antonov has a hand up. Sergei.
Okay, here I unmuted myself. Hi, everybody. Marianna, this was a very interesting. I enjoy your work very much. And my question is actually sort of about your research project in general, because it occurs to me you're one of the very few people who has read 18th century cases and 19th century cases and early 20th century cases. So would you like talk a little bit about like this process of reading legal documents and like how sort of different ages sort of impact your work in different ways in terms of these documents were put together and the cases were processed and stuff like that. So I'm going to stick with that question. I'll let you talk. I mean, I have a lot of questions, but that's it's okay. Thank you.
Yeah, thanks very much, Sergei. It's a huge, of course, question as usual. I've sort of decided at some point that I would like to see the original sources rather than to go trust research on that. Probably quite sort of uncollegial of me to do that, but I was trained like that. My first education is in history, so I was trained that you always have to check the original source, and my legal training was always like that as well. Like, you cannot trust anyone. You have to go and check the source, which created a situation in which I've really looked at cases between 17th and 21st century. So basically I have that span. And it's interesting that there's a very ambivalent, my approach is very ambivalent. On the one hand, they are different, the way they're generated, the way, of course, because these are not the cases, the cases that what we call intentional narrative, they're there teleologically, they have a very particular goal, they're structured around a particular event, and they're structured in a way that you rarely hear the authentic voice, right, of participants. That is one thing. So you can, but you have to work for that. So the analysis should be such a sensitive and subtle analysis, and where you need to deconstruct the case to actually get to that authenticity of voice, if we even believe that it could exist in a court trial, right? Because there is a part of the scholarship that don't believe that you can actually get anything from these cases, because they are the original speech, right, is reused so much by the end of the case file, right? So by the end of the trial, that you can never sort of get to the gist of it. I think we're better than that, and I think using actually hermeneutics and narrative analysis, we can do that. I think we are able to do that. But at the same time, while acknowledging that all those cases are different and produced differently at different times, because there were different priorities of the state, of the court system, bureaucracy, of course, contributed and all that. At the same time, for me, those cases are similar, especially in its contents. And what's interesting, and it's a particular way I'm also looking at those cases and try to do that analysis in the Russian monograph. So in Russian language, I actually sort of consistently try to show that it's fascinating how we reframe the same act, but we transform that into a very different deed, and that happens in this narrative. And even, if you look at the 17th or 18th century complaint narrative, for example, like appeal and a complaint culture, it's very similar to what you have in a complaining to president today. Oh my God, dear president, so everything is bad. My sister takes away my money. I mean, we've done that project. Elena Bogdanova wrote a book about it, and I've participated in that project where you have the same types of complaint from mothers in the 17th, 18th century. I published an article on that, where they complain against you. Oh my God, I have this son who drinks, and he doesn't go to church with me, and he abuses me every day, and he insults me with the words blah blah blah. So that goes to and And that there's a complaint that doesn't go to court, it goes to the empress. And this particular one is to the Empress Anna in 1833. And Empress orders investigation, to take mother into the monastery, to protect her there, because the female convent, of course, is the place. It's our early idea of shelters, and to punish the son, blah, blah, blah. And you can see the same sort of, the flavor of complaint today, although like 400 years later, we think and we assume it's different. But I think I liked Anna's comments on that you have that idea of the cultural, that's a part of the cultural development that we underestimate a lot, looking at social and economic, but it's there, and we need to be probably paying more attention to that. So legal narrative is just not about law, it's about law, yes, but it's a lot about reflecting on sociocultural patterns and structures, and basically taking into account and providing structures and explanations in return for what the state and the society wants, and it's often the same thing. That's the problem. And in a sense, I sort of try to encourage everyone to go beyond their fields a little bit and do the long-term projects, precisely for that point, because otherwise we don't have a perspective for that. Because in a sense, it's interesting for me. It was always challenging to see if it's really different or is it the same. The crime is the same, but the narrative is different. So that is, it's in the short. I put this in the short explanation. So again, thanks very much for the question.
Thank you, Marianna. We have a question in the chat from Ani Abrahamian. She says, thank you for this presentation. You mentioned a very intriguing sociocultural concept at play when discussing the father's adherence to, quote, model patriarchal behavior, unquote. I'd like to ask whether it had been reflected or formalized in more detail by legal language. Thank you.
Yeah, thanks very much for the question. It is, in fact, there is, in fact, a model patriarchal behavior in a sense that how the law structures that. And in fact, if you look at the legal legislation, even before the formality of the code, so if you go back to, say, 16th, 17th centuries, and for example, this analysis usually comes from the contrary, like in mathematics. Let's assume that. And so for the early modern legal provisions, such sources, for example, is Kormche, so Kormche Kniga, which is the Codex Canonici of the Russian Orthodox Church. And even on Kormche, you have a lot of rules. Okay, there is the apostolic rules, there's ecumenical council rules, there's this rules, that rules, there's a Bible, blah, blah, blah. But then there are, of course, Byzantine legal codes translated into Bulgarian first and then into Russian. And all of them are about rules. And all of those rules, and we often, I mean, as a women's historian of sexuality, of course, originally, I come from this long tradition of analysis of the rules that the oppressive or that regulates the behavior. What it's all about also, it's a lot about how men are supposed to behave as model patriarchs. And again, subtly, you can see how in 16th, 17th, and 18th century, that model behavior changes to be from being model patriarchs into being model citizens and model heads of families. And also, contrary to some research, that was early research that showed that, okay, there was a absolute state of autonomy in Russian families. There was autocracy, nobody interfered in the families very much. It's actually not correct, you know, the public authority, the state, not just in Russia, in France, in continental Europe, everywhere, from early on, try to control patriarchs' behavior via modeling their behavior and also creating legal situation in which patriarchs also not just reported to the state, but were held accountable for their behavior. And that's the answer, all the crimes against the family. And the Russian codes also have this abuse of parental authority parts of it. So in where they actually showed what patriarchs are not supposed to do, right? And patriarchs are not supposed to do, for example, force their children to marry or force their daughters to go to take a veil in a monastery, etc. That reflects the certain ways in which they wanted these people to be. But in the Russian case, again, this is a tremendous difference in how this masculinity model, patriarchal masculinity and fatherhood is structured mid-17th century and mid-19th century. That is your evolution into citizens. And there's some research on that in a different terms, not probably in a gender sort of specific terms, but in terms of changing family structures or social behavior. But even looking at it in perspective in a family conflict, fathers are being held increasingly accountable for their behavior in the family. And what's fascinating, husbands are being held increasingly accountable for their behavior towards their wives. Children come very late. Thanks to 1917, actually, children get their protection only in Soviet and Bolshevik first legislation. So in the 1920s, not before that. Before it's very scattered. But wives had been there for quite some time. And so that's another way of looking at what this model behavior should be. But in a gist, looking from the country, from the complaints, from the court cases, this masculinity was supposed to be so the men were supposed not to abuse, they were supposed to discipline and correct by love. That is everywhere you can see. They were supposed to provide, and they were supposed to maintain peace and security in the family, but also peace and security with neighbors. So that would be in a gist if you look at what they were accused of not doing, right? So that's what you see, that what they're supposed to be doing in a sense.
Thank you, Marianna. Other questions? I know there's a lot of rich material here. It's really amazing and dark.
But anyway, there's a book and there's another book.
Yeah,
and,
we will look forward to it. Thank you very much, everyone, for coming. And we look forward to seeing you in a couple weeks. And thanks especially to Marianna and Anna. Bye. This
Thanks
was
very
great.
much.
Thank you.
Thank you, Anna. And thank you, Anna, very much for great points. So I wrote them all down. Cheers.
Thank you for the paper.